Mr. Lehtinen, you're on.
With respect to the Palmer Trinity matters, they are unlike a lot of legal issues which are more complicated than they may first appear. The Palmer Trinity issues are actually simpler than they first appear because of the point at which you are now. The land use disputes were finally determined in 2012. That is to say, what Palmer Trinity was entitled to do as a school. Those disputes that sometimes would be characterized as Palmer Trinity vindicating their rights by court orders and the village conforming, on the side number of students and so forth. But those were finalized in 2012. Any land use issue that currently exists is a new application to be considered on the merits. May be granted or not granted, like lights were unable to be granted as long as the code prohibited them and so forth. But land use disputes are over with. The new applications are just new applications to be considered on their merits, and Palmer Trinity has one of those community meetings coming up. The litigation, which is often described as part of the Palmer Trinity disputes, are practically part of them. The litigation arose from the delay that Palmer Trinity alleges were involved in the land use disputes. But that litigation is not a land use dispute. It's an argument over whether a certain delay constitutes violation of due process and whether it's compensable by monetary damages. A lot of them are federal claims, as a lot of lawyers do, that throw out the 14th Amendment and this amendment and that amendment and so forth, which are important amendments as citizens, but it's common in the law to allege violations of the 14th Amendment in all kinds of different circumstances. So let's deal with those. What I say here, and this is posted or will be posted on the website as well. What we have here is simply a statement of what I just said, that the current litigation with Palmer Trinity is civil rights litigation. It's an argument that they make that they were deprived of due process in various ways during the land use disputes, and that they had to vindicate their rights through the courts. And once those rights were vindicated as they saw them in 2012, they maintained that the delay that came about, not that the 2012 decisions are improper or being challenged, or that there's anything wrong with the 2012 decisions. They could go forward and build based on their site plan and their current development agreement, 2012. But their argument is that what they had to do to get to 2012 constituted delay that should be compensated by money. The point is that these are not litigation that can be settled by giving them a land use utilization, different land use. Consider it this way. If the code prohibits something and somebody has another lawsuit that says we want 10 million, but we'll take 200,000 if you change the code. No public agency is, able to sell its code, to sell its public process that way. Not that were the code changed, it would be that. It's simply that if the code is changed for any reason, it has to be village-wide and done on the merits. And with respect to lighting, there's some communities have lighting, some communities don't. It's a matter of public policy. This community right now has a prohibition on the lighting in the residential areas, which Mr. Hoffman, who represents this village, under your insurance with the Florida League of Municipalities or whatever that entity is called, he and I are both confident that it's not unconstitutional to to not allow a school to have lights. Actually, it's not unconstitutional to allow them to have lights either. It's a matter of public policy that's determined in the democratic process. So, not only does the litigation is not over land use matters, the judge were the judge to rule entirely in Palmer Trinity's favor, which I hasten to add that Mr. Hoffman does not believe will happen, nor do I. He's authorized me to say he does not believe that Palmer Trinity will prevail, and I do not believe they will either. However, were they to prevail, it would be money. The judge could not order lights and could not order site plan changes because the litigation is over money, and the judge has no more authority to order land use changes in unrelated litigation. Consider that litigation to be like an auto accident. Maybe there's a lot of money at stake, maybe there isn't, but you can't compensate somebody for the auto accident by changing land uses. What do I do? Yes, Councilwoman Lindsay covered this, but and the details, the actual numbers may be unimportant, but the general concepts are here. Of the 14 counts, 5 of them, or 4 of them, I believe you said 3, but the numbers are, 4 of them do not involve the village. 1 of them that involved the village is dismissed, so 5 of the counts don't matter. There are either 3 or 4 or 5 counts that allege federal civil rights or constitutional violations. I say 3 or 4 or 5 because you can read certain of the counts and they seem to, as the old people would say, or Matlock would say, they seem to sound in state law. However, they'll end up with a conclusion that everything we just said violates the U.S. Constitution also. So, if it violated state law and it violated the state constitution, yeah, it probably violated the U.S. Constitution as well. If, I just say if. So, there are 5 counts that, in one way or another, claim this would be a violation of U.S. constitutional law. Now, why does it make a difference that there are federal counts and so-called state counts? Because the village, like almost all municipalities in Florida, is insured against federal claims, which may sound strange. Why would you insure against federal claims and not state claims? The reason is that you have state-established sovereign immunity with regard to state claims. With regard to fundamental U.S. constitutional claims, that's the 14th Amendment, it's the post-Civil War amendments, where Congress found it necessary to override state sovereign immunity, during Reconstruction and so forth. The history is unimportant, except to recognize that the federal government's overriding state and local sovereign immunity was an important element in enforcing civil rights, and getting rid of the black codes and so forth like that. So the point is that your sovereign immunity does not protect you against federal civil rights violations. So all municipalities purchase insurance against that, which pays 2 different elements, of course: the cost of defending the lawsuit, legal fees, and the cost of liability. Your liability policy is $5 million. You've read this or heard this before, but I've talked to your insurance people to make sure, and looked at the policy. It's $5 million per occurrence, which means actually if something happened in 2008, which neither Hoffman nor I believe is the case, but it's alleged in 2008 that resulted in liability, that would be 1 occurrence. It might violate 3 or 4 provisions: state constitution, federal constitution, this, that, or the other, whatnot. But it would be 1 set of damages, and you'd be covered for that. And then if there was something different happened in 2012, that's a different occurrence. Your policy is not $5 million total, it's $5 million per occurrence, which is actually a nice policy. That's why the federal claims are important. Now, I'll mention later that federal constitutional principles generally do not provide monetary relief because of delay in land use proceedings in the state. The U.S. Constitution, the Supreme Court views the proper remedy for a denial of a land use matter as being an appeal. And if you win on appeal and the court system gives you a remedy, you've got your remedy. Just in case you're wondering why you haven't read in the newspapers that every time somebody wins a land use decision on appeal, they don't end up with a due process claim, arguing that between the time they were denied and the time they won on appeal, they've been denied due process. The general view is your due process is vindicated in court, and if you don't like the length of time it takes the courts to decide it, do something about the courts. But you're getting your due process as long as you're being granted your right to appeal and your right of access to court and so forth. But anyway, that's just a comment about the viability or lack of viability of the constitutional claims. The next issue is there are two state claims that do not involve money. One of the claims is that the state statute that explicitly permits communications to the governing agency in a quasi-judicial proceeding as long as the government officials reveal the communications, and the statute is routine. One argument, and most municipalities and counties rely on that in Florida, one argument is that that is unconstitutional, and were that the case, there'd be hundreds of municipalities affected by it, and it would only change that law as well. We do not believe that good faith reliance on a state statute should not result in monetary damages. As a matter of fact, you're likely to be more likely to be expected to rely on a state statute than to look at a state statute and say, fine, on the state legislature, we don't care what they say, we're going to do it differently. Meaning, relying on a state statute is reliance on good faith. It's hard to argue. That's kind of akin to what Councilwoman Lindsay said about the fact that, the reason she emphasized it, by the way, that when the council denied the zoning, the first appellate division upheld the council's action, and then the Third District Court of Appeal reversed it. The significance of that is that a judicial panel found the municipalities, the village's action to be reasonable. So in order to claim that there was a gross violation of fundamental rights, you really should be suing those judges who, at the first level of appeal, said the village had acted properly. As a matter of fact, they would actually be the cause of the delay between their decision and the Third District Court of Appeal, but you can't sue the judge, of course. And that's mainly the reason you can't sue the municipality either for that kind of delay. Now, a lot of you have been caught in delays in the court system, and they're very frustrating, but the remedy is to get the court system to act a little faster. Now, the other two, there are two claims, and when I said there were 5 federals, 3 of which were clearly federal claims and 2 of which had federal language tacked onto them, that means that there are 2 state claims, purely state claims, or 4 if you decide that the other 2 that tack on that last bit of, oh, and by the way, remember the 14th Amendment, along with the 14th Amendment kind of language that makes it a federal claim. If they were not federal claims, then you'd have 4 state claims that conceivably could produce monetary damages. Now, generally, Florida has also not recognized delay in land use decisions that are properly going through the court as being a violation of due process. But if it did, then these could provide monetary damages. The complaint cites a bunch of language like deviation from the fundamental requirements of law and so forth, and repeats that and puts it in bold and so on like that. Not a very professional way of writing a complaint. But I would point out that those are simply the legal standards, that whenever the Third District reverses on a basis of a petition for certiorari, that exact language will appear, that there was a deviation from the fundamental requirements of law and so forth. And that the reason that's important is because if you were to read the complaint and equate something like a deviation from the fundamental requirements of law, initially sounding like it's a due process violation, that would be incorrect. Or else every time the Third District Court of Appeal granted a writ of certiorari, because of a deviation from the fundamental requirements of law, you'd end up with a damage lawsuit for a violation of due process, and that is not the case. The state's standards of review, and when they find that they want to reverse a lower court, the language they use does not automatically, or almost never, itself establishes a violation of due process. In fact, it's often argued correctly that the fact that you're in court and are able to get an appellate court to make that statement in your favor actually proves that you have been given due process. You've been given your day in court. You won or lost below, you won or lost higher up. That's what due process is about. It's not outcomes, it's that you're given a chance for a hearing. Now, the other thing about the state claims, the reason the classification is important, is with sovereign immunity, neither this municipality nor most municipalities or counties in Florida bother to buy insurance for state claims. Why? Because you either have absolute sovereign immunity, or the state legislature, out of a sense of fairness, has waived your sovereign immunity, and the counties and the states, only up to $100,000, but has waived it for personal injury torts and for property damage torts. What is that commonly? One of your village vehicles runs over somebody and causes personal injury. If the state legislature did not waive sovereign immunity, that injured person would have no remedy whatsoever, which seems rather unfair. So the state legislature has said, in those cases, personal injury torts and personal and property damage torts being an injury to another, based on a violation of the duty of due care. That's the kind of first-year law school statement of it. That you can go to court, and if you get a judgment, you can collect it from the village or the government up to $100,000. Now, if you get a $2, $3, $4 million judgment, you get $100,000. You are allowed to go to the state legislature and get a legislator to file what's called a claims bill, and the state legislature looks at that judgment for $4 million to see if the legislature wants to waive sovereign immunity to a greater amount. And sometimes they do, often they don't. When they do waive the sovereign immunity and tell the local entity to pay the bill, they almost never allow the high contingent fees that are in there. They put a condition on contingent fees can only be 10 or 15%, not 33. And they usually deny punitive damages. I'm just saying to you from experientially what happens. However, that's actually unimportant as well, because your policy covers you if the legislature passes a claims bill, which is mostly we're very careful not to say something certain. But I've heard that the earth revolves around the sun, and I'm about as certain that the legislature wouldn't pass a claims bill in this case as I am that the earth revolves around the sun. So that's really not a risk. But the point is, it doesn't matter because you're covered. By the way, the reason you get that in your policy is because the insurance company doesn't think the legislature is going to pass a claims bill either, okay, which is why you don't pay a high premium for that. But the point is that were you to lose certain state claims, there would be either no damages. You might, if you're a budding law student, say, well, actually, if you have sovereign immunity, you shouldn't have to defend the case, but sometimes whether you do or do not have sovereign immunity depends partly on the facts of the case. So, but in certain instances, you don't even get the case tried because it's clear you have sovereign immunity. But you'd either be owed nothing or you'd owe $100,000. And you would, if there was only the state claim, then you'd have to pay your own attorney's fees. But your policy does provide that if the league is defending you for federal claims, any federal claims, then any of these trail along state claims get defended under the policy as well. Now, it is true that if all of the federal claims disappeared, then you would be defending the state claims, not so much worried about liability, but you would be paying attorney's fees if there were no federal claims and there were only state claims. It is practically very difficult to see how a set of facts that are just alleged, and then you throw in there that violates the state constitution, and it violates the federal constitution, and it violates like the UN Charter, if you talk a lot about that. It's very hard to see how the federal claims would disappear and the state claims would not. You can probably think of one way. Ms. Lindsay's a former teacher, so she did that to you, right, like my wife does. Just ask a question. She couldn't resist it from the podium. But I would ask you, is there one way that the federal claims could disappear and the state claims remain, and that is if the plaintiff voluntarily dismissed the federal claims and not the state claims. But the federal claims are the ones that don't have sovereign immunity, so they're not going to voluntarily dismiss those just to make you pay attorney's fees. Well, having said that, maybe I'm wrong, but the point is that if they voluntarily dismiss those just to leave you with state claims, that's a significant victory on your part. I wouldn't worry about that. That strategy, that's like the Indianapolis last night, not Prowler's putting up in the last 30 seconds. Okay. I think I've said that, not insurance statement. Okay, here's a list of these counts. The only reason you want to take this off the website, if you were so inclined, is to see that they really are quite repetitive. An argument that ex parte communications are unconstitutional is a little bit different than saying if they were constitutional because they're revealed, then there was a violation because they were purposefully not revealed. Hoffman and I, as lawyers, believe our clients. We have no reason to believe there were ex partes purposely not revealed. But what can I say about that? It's just kind of thrown in there. You see, number 5 is a true federal claim that it's an equal protection violation, state claim as well, to treat public schools differently from private schools. The only thing about that is that Hoffman and I have never found that to be the case. Public schools and private schools are almost always treated differently in zoning laws. And were they to win that, it would have national, I guess not international, but national significance, because there's probably no code nationally that doesn't have some form of distinction there. The Citizens Bill of Rights is not a monetary claim. Public records, probably the only place that that you're not insured is like this public records claim, because statutorily your sovereign immunity has been waived. That's where a citizen has a right to get a public record, and if the entity denies the public record, then they can sue and collect attorney's fees for the need to sue for the public records. So theoretically, there's an attorney's fees claim here, but I don't believe you can just bury a public records claim in a big lawsuit and then not diligently pursue the public records claim and then try to sweep every legal fee related to everything else into a so-called public records claim. My experience is not important, except I chaired that committee once in the legislature and have successfully sued many times, and I cannot envision why, if they had a public records claim, why they haven't pushed it, or tried to get the public record or whatever. That's an independent claim. I think it's kind of showboat kind of stuff, in the complaint. Of course, I don't have personal knowledge as to whether there's a public record that was denied or not, but if they think they do, they should have pursued it, not just bury it in some complaint here. Then Section 1983 is a jurisdictional statute, a federal jurisdictional statute that gives the federal courts jurisdiction to hear civil rights violations. It's one of those Civil War efforts, so it doesn't really add any new claims. It's still due process. And by the way, what would the due process claims be? That it was wrong to deny them zoning? Well, an appellate court first upheld that. You were right, so that one's not really very strong. Then there's you were wrong to put a 30-year restriction on and wrong to do 900, but that was corrected by a judicial decision, as I've said. Usually your due process is deemed to be a government mistreats you, your due process is to get it corrected. And that was from viewpoint of the plaintiff, that was corrected, so, you know, we'll see that. But that's where those claims would be. Abuse of process, technically speaking, that's a really silly count. That's kind of a legal term, silly. Abuse of process, the way it's pled is it's just constitutional claims again. It's the duplication of the earlier count. A real abuse of process is when you process means service of process. You know, you suing somebody improperly or using judicial process improperly. There's nothing new there. Conspiracy, it's pled so that you don't know what they're conspiring to do. So it's either federal, state, or, as I said, something else, but it's not new. Whatever the operational facts are, claim to be 600, 900, 1150. Conspiracy is the same thing. And then not village, not village, not village. Of course, it all depends on where what you see depends on where you sit. If you're one of the not village people, that's important to you. You know, one of the defendants there, I'm not trying to diminish that, but it ain't, you know, it isn't our job, it's somebody else who's been sued. But they have all of the same offenses. And the temporary injunction they're not pursuing, but if they did, it's not monetary anyway. Okay, a couple of closing comments. On the substantive law, these claims have generally not been recognized as providing monetary relief. Your relief for a land use decision of the government is a proper appeal, and you're vindicated if you win the appeal. And that's what they had, you know, about the insurance coverage. You know about sovereign immunity, I mentioned that. Okay. Damages, so let me say this, it has been asked several times, so I should say. The one set of operative facts, if found to violate some legal principle and give rise to damages, would be the same set of facts if it violated some other law doesn't give rise to damages times 2. Okay, if something the village did violated 3 laws, you don't get 3 times the damages. You just get one damage. That's important for your per occurrence part of your insurance policy, right? Because if you get 5 claims against you, but they're all the same thing, the 600, 900, 1150, you know, just to identify it by title. If that violated 5 things, they get damages if they qualify one time. You have a question?
I just wanted to ask you which kind of damages
Okay, so, you mean how, okay, let's go to that. The interesting thing about damages is that, again, to take it in sequence, not to be too repetitive, we don't believe the substantive law recognizes monetary damages. If it did recognize monetary damages, it would only recognize one damage for if something happened in 2010 and violated 2 different laws, you get damages from 2010 forward. Now, notice this. The 2008 complaint is very difficult to see the village doing anything wrong because the appellate panel said you were right. So they've got to be wrong too. Now, I often tell law students, you know, if you can identify the legal issue and apply it cogently, I really don't care what outcome you get, because look, we're reading cases that are 4-3 in the state Supreme Court and 5-4 in the U.S. Supreme Court. And, you know, theoretically, they all pass law school, the 5 and the 4. So I don't see how the village can be liable when the appellate panel thought you were not. The next panel did, but that's not unusual. We often count a 5-4 Supreme Court decision, and then we look on the lower panel, and it was 0-3, which meant if you count federal judges, there were 5 one way and 8 the other way. And then you look at the first judge was that way, it's 5-9. Now, why did the 5 win? Because they're like the Supreme Court justices, okay? But it's 5-9. You can't claim those 9 judges below or the 4 co-justices, you know, were acting in bad faith or anything like that. The next point, interesting point, is that you probably noticed the claim from my statement that, and Councilwoman Lindsay's as well, that this was all resolved in August of 2012. So in August of 2012, the plaintiff could build. And if they haven't built in August of 2014, there's 2 years their own behavior demonstrating by their behavior that they were not prepared to build for at least 2 years. And notice that the 2010 violation, alleged violation, was corrected in 2012. So if you had a 2010 violation, and if it gave rise to monetary damages, if the school could prove that they were ready to build the minute they got it approved, then what happens with the fact that in 2012 they didn't build the minute they got it to be approved? What you might want to do logically is take the amount of delay between the approval in 2012 to now and work that back, as at least that much is not delay caused by the village. That's delay caused by, whatever else. Of course, that's just a point of reference, a point of argument. Okay, I don't think we need to do the complaint. I do find it necessary, just for my own mental well-being, to quote one of their statements. Let me go to the next one. According to the Florida Rules of Civil Procedure, the federals as well, a complaint is supposed to be a short, plain statement of the facts showing the pleader is entitled to relief. Actually, that's a paraphrasing of the actual rule there, right? And you go backwards, look at one of these allegations. This, by the way, is an exact quote. I didn't put sick in there, because the Latin phrase, but it is bold and it is underlined. And it does have a capital E after the comma. The pleading is, simply put, enough is enough. Now, I taught civil procedure once. I'm not saying that the rest of that parts of the complaint aren't written in English, but in all honesty, that's really, you wouldn't pass Civil Procedure 101 with that kind of rhetoric in a complaint. It is true that just because you're paranoid doesn't mean somebody isn't out to get you, just because it's a silly complaint. 65% of the time doesn't mean you can't weed through it, go through the weeds, get rid of the rhetoric, and try to figure out what the actual claim is. And it's not Palmer Trinity writing it, it's their lawyers. Okay, what else do I say here? What's that say? Oh yeah, completed. This is the completed thing. It was all completed in 2012. They could have gone forward on 2012. They are properly applying for amendments now. The fact that there were disputes previously, and the fact that there was other litigation, as long as you're a public entity, you still have a duty to treat whatever application they have right now, on the merits right now. A private party can say, you sued me 10 times, I don't like you, I'm not going to do this 11th thing for you. But a public party can be sued 10 times over here if it's, that's not supposed to change the public entity's proper application of the law, on the current community site plan. I think everybody knows that. But my point is that the site plan, just like the lights, is really not part of a settlement. I do know that the council looked at various elements of a proposed settlement and gave some advice to go forward and work in that direction. But the current Palmer Trinity site plan should be considered on the merits of it. What's good for the village and good for the school as a party, somebody in the village. And not to settle a lawsuit. The private party doesn't act illicitly when it tries to use litigation to get leverage. At least that's what I've always taught. However, the public party acts illicitly if it lets the private party succeed in using the litigation for leverage. And this is a quite distinct thing, meaning a private party isn't illicit to try to talk a public entity into giving it more in response to a lawsuit than the public entity should give. That's just all of us. That's what the founding fathers said we all are. However, the public entity needs to separate them out. The monetary damages lawsuit you look at alone. The site plan you look at on the merits, give it to them, or do whatever you wish on that. And code changes to the entire ordinances of Palmetto Bay get looked at on the merits as well. The one that's pending or there's some reason to believe won't be pending. Well, anyway, I'll ask for questions. Thank you. Yes. How do we handle that? Do that for me, Meg, or Ms. Allen. Does it work?
Okay, I may be wrong, but I don't agree that this pending lawsuit and the zoning are independent of each other. It's obvious to me that Palmetto Trinity does not expect beginning damages. These lawsuits, or some of them are extremely frivolous, that they don't expect to change the state and U.S. Constitution for this case. I think they're using this lawsuit as a way to extort more on the land use and zoning side from the village than what they currently have. And that explains why they haven't started building. Because once they start building on the approved plan, they commit to that plan. They want a lot more. And they're not going to drop this lawsuit, and they're not going to start building until they get a lot more. And that is the danger that we're facing here. They're using these lawsuits, which they have no hope of ever winning, to bully the village and the residents into getting a lot more on the building side.
Well, I may have misspoke or given them the wrong impression. What I intended to say is that as a legal matter, these lawsuits should be treated as lawsuits. And not only should you not, but you as a public entity really don't have a right to give substantive land use changes in response to a monetary lawsuit. It is true, however, that private parties often act that way with other private parties, and they often do it with governments, and rather than being surprised that it happens, I just find it appropriate to simply say their link of the lawsuits and the land use, though not illicit in their mind, is not something that this public entity will do, either with the people that represent it or with me as the village attorney. I mean, I don't control it, but I mean, that's, so I guess I'm saying they're practically linked and perhaps linked in their minds, but they're not linked here. That site plan will get reviewed on the merits, and the lighting will get, that ordinance change will get reviewed on the merits, or not reviewed if it's withdrawn, as it seems to be indicated it will be. And then the lawsuit, you need to decide how much, what you want to do with it, nuisance value for it and so forth like that. That's really when it comes to actually what to do, how much to pay them to go away on the lawsuit. That's really Mr. Hoffman. I think he once put a low nuisance value on it, but that was before, so it would only be fair to have him. As long as you're talking just about monetary damages, then you've got it separated over here, and you might want to buy him out for something. It's not. I'm told, I was not present, but I asked him one time, and I think he said he put $50,000 on it, but that's double hearsay. Was somebody here to hear that? I don't know. But you know, the point is, it wasn't millions. It was something because it costs, and by the way, the league can settle for a certain amount without your agreement. That's like most insurance policies, you know, if they think, well, you're going to win, but it's going to cost X amount paying off, and so we'll just, they can do that without your agreement. You agreed in the insurance policy. They can settle as long as they pay it. Yes.
There was a resolution passed by the village council authorizing a settlement. What's the effect of that resolution?
I believe the effect of that resolution is to, well, motion, yeah. Motion, 3-2.
Whatever you call it.
Something 3-2. I believe, and this has been discussed, I believe the effect of that is that village staff, including the village attorney, are supposed to read it carefully and attempt to go forward with that when possible. To the extent that it referred to lights, I said lights are against the code and that cannot be done. That discussion, by the way, also acknowledged at that meeting that there was some issue with lights, but you know that it might be difficult. And secondly, I would say it's go forward as is appropriate under the law, and I don't believe that the site plan should be linked to a settlement as a matter of law. It is an indication, probably arithmetically, so to speak, that if there was something in that directed to staff that said something that would be changed in the development agreement, staff should probably prepare a proposal that would change that element in the development agreement, because they got direct, but there is no legal effect. Well, there's a legal effect because staff looks and says, well, 3 out of 5 have told us to go forward as best possible to do X, Y, Z, and if that took a change in the development agreement, they should probably bring it back to the council. But the council would vote brand new, all over again, from ground zero, as to what to do. The council is not bound by that 3-2 vote. But staff is probably under a good faith directive to do that and bring it back to the council in a legal form so the council can act up or down on it. Now, the reason lights won't come back is because I, among others, and I'm not the key guy, but I mean many people, but probably the actual charter position of village attorney that says lights are against the code and would take a code change, that meant that the reference to lights there was not operative. They were not going to come back with a development agreement change that gave lights, because we said lights were illegal, to use a point of phrase, or undocumented, to use another. Lights are undocumented facilities, undocumented aliens, illegal immigrants, undocumented immigrants, get the joke, undocumented facilities. So that went off the table. And other things there, they would be expected to come back to the council and say, you wanted this, this, and this, and here's the resolution, or here's the document that would do it, but they vote brand new over again. So it's got either a lot of significance if you count 3-2, or it's got no significance if you're asking legally. Does it mean anything? No, there is no settlement.
Was it an offer by the village to settle?
Well, there was a give and take, but the list that was used at the time was from a piece of paper written by Palmer Trinity's lawyer, but it was written after discussions and so forth. So who scribed the list from which they read may not be completely indicative, meaning it was like not totally theirs, kind of like, who wrote down the Constitution, I mean, Jefferson may not have written it. We say he wrote it, but it might have been somebody else in the room he was dictating to. But it was started as a proposal from Palmer Trinity.
If we had the quiet enjoyment law in the state, would we have more protection? Because it seems like every time we go against it.
Well, that's a fair question, but it's a very, land use is a constant tension between the constitutional rights of the private property owner and the admitted constitutional rights of other private property owners who are interfered with by the crossover effects. There's not the lights are a perfect example. They're on one piece of private property, but they show and light up another piece of private property. So depending on what you mean by a quiet enjoyment law, you almost always, sometimes one would, that phrase, kind of be careful what you wish for, because you may get your wish. What you really want is most of the policy decisions to be vested in a democratically elected government. Across the board, quiet enjoyment laws and things like that can come back to haunt you. You have to have, I don't mean to, I just mean this legally, I don't mean it as a social science thing, but just my experience in the legislature and elsewhere is that Oliver Wendell Holmes said it too. You cannot write a law that exactly covers everything in the future. You've got to put your faith in the democratic elections, or not just your faith. You've got to go out and elect the right people, so to speak, from You can, I was asked whether you can put no lights in the charter, and I think you can. And you can put it in the charter with a phrase that says this is self-executing, which means it's not implemented by ordinance, that the charter itself is enforceable. That's not what the 10.2 does. It says do it by ordinance, but you can do no lights exactly the way 3110 does it in the charter and say this provision is self-executing, and it would be the law. But even that's changeable by a majority vote, so nothing is permanent. Majority vote of the electorate.
You may have just answered that. My question is that you were saying about the code. Now, the lighting as it stands, if before they said they weren't going to do it, I sort of don't believe that. I think that what may happen is that later they would vote to change the code if it's not put in the charter. Now, you just said that if the lighting is put in the charter, that we don't have this crazy lighting. And they can still change the charter then at a later date, or is that charter mandated forever?
A majority of the electorate can always change the charter.
What about the code? They can always change the
The
code.
majority, well, technically, strike the word technically. The ordinances are normally changed by a majority of the elected council. Your charter does have provisions that allow ordinances to be submitted to the electorate, or the electorate to challenge an ordinance and then take it to an election. Or the simpler thing is just amend the charter. But no document, including the U.S. Constitution, is enshrined forever. It may be difficult to change, but we put a federal income tax in there, which is the one I find amazing. I would vote for it, but I mean, when we often say the U.S. Constitution is impossible to amend, the fact is that after the Supreme Court struck down the income tax as unconstitutional, 3/4 of the state, 2/3 of the House, 2/3 of the Senate, and 3/4 of the states approved the federal income tax. So when you pay your federal income taxes, blame 3/4 of the states. So it is, everything's amendable. And perhaps this is too detailed, but the reason you're amendable by majority vote is because all municipalities, their charters are controlled by the Miami-Dade County Home Rule Charter, which says it's majority vote for a municipal charter.
And that would be in the city, not necessarily Dade County wide.
Well, yes, in the city.
Okay.
Palmetto Bay changes its charter in the city with 50%. The state legislature changed the state constitution to 60%, and that passed with 58%, interestingly enough. The amendment, 50 to 60, needed only 50, and I got 58, so it's there, so now you need 60.
Gary Pasquarello. I think we have some representatives that are presently looking down at their feet to see how big the holes are for having brought you on board. But first, would you, as a litigator, is this a case that you'd like to take to court? And secondly,
If I was the plaintiff for the defendant,
the defendant, you're being sued by Palmetto Trinity. Would you like to take him to court? He is the defendant.
you need to make the decisions on what's good for the village. But how would I feel if the federal claims were dismissed and the state had to go there and I got to defend it? It would be really fun.
Another concern that I have, the vote that was taken recently that gave Palmetto Trinity both the zoning monies and the monies in settlement and included modifications to the site plan, that may now be null and void?
Well, that vote was not null and void at the time, but it was a vote, a sense of the council vote from my viewpoint, which is legitimate, discussed, and 3-2, and therefore staff, seeing that the majority wanted to go in a certain direction. To the extent that you can go in that direction in settling the lawsuit, staff was supposed to work on that, but it wasn't a done deal. it was not a settlement, it was just directions to staff to go forward. It was a good sign for Palmer Kennedy. He was telling staff more or less what to do. However, since staff has to act in a fashion consistent with the law, the lights got struck out of that like right away. And then site plan changes have to go through the quasi-judicial proceeding in which we have to assert both on the record and have to mean it in truly good faith. We are deciding it based on the evidence that's presented in the quasi-judicial proceeding. Even if it's presented by somebody we don't like, or it's presented by somebody we like, or anything else, it's supposed to be based on the hearing. So it's okay in a practical world to notice that certain people seem to favor certain changes to the development agreement. There's nothing illicit about that. But it then has to go through the proper proceeding. So later, it will be defended by the village or by me as having been done purely based on that site plan application and the law applicable to that site plan application, and without regard to prejudgment or the fact that if we give this site plan application, we're likely to escape some monetary damages. Nobody would say that, and you can understand why. It would not be an intention to sell public policy, but working through kind of Aristotelian logic, you would see that we gave a site plan change in order to save money. That's selling it, and nobody intended to do that and wanted to do that. And I think the village properly expects the village attorney to separate those things out, and that's how they're separated out. The lights are an ordinance, the site plan is a quasi-judicial proceeding, and the litigation, which is, a lot of money, is litigation.
Well, it seems there may be a quid pro quo on the part of the representatives, I don't know where or how, to put forward such, like the lighting and things such as that. So it just seems awful strange all of a sudden this lighting issue is something that has come up on the part of Tim Schaefer, where it was, they now, attorney realizes they can't get it.
Well, here's the tension between the First Amendment and Robert's Rules, because the First Amendment clearly allowed people to articulate their beliefs about motives and so forth. Robert's Rules of Order says you're not supposed to question somebody's motives in a proceeding. I'm just saying that's why the First Amendment repeals a bunch of Robert's Rules of Order.
By the way, speaking of articulation, if members of the public would wait till I come to them with a microphone so that you're on the record. Thank you.
Firstly, thank you very much for the free tutorial of constitutional law. I'm sure we're all learning a great deal. My question concerns the 3 lawsuits that Palmer has against us at the state level. If I understand correctly, Palmetto Bay enjoys sovereign immunity, and the only way they can collect a remedy from us would be if the legislature would provide them with that opportunity. And historically, that's been limited to tort claims of $100,000.
Right. Personal injury tort.
Yeah, so my question is could those 3 suits be considered frivolous? And if indeed they are frivolous, would that provide Palmetto Bay with a cause of action for those 3 suits? And also one other question concerning Florida civil procedure. I'm not familiar with it, but I don't believe an attorney has a right to file a frivolous lawsuit. And if we can get the courts to say this is frivolous, do we have a cause of action against their attorney?
Well, being personally the proud defendant in a number of frivolous lawsuits, one of which has been dismissed and is going to a hearing shortly about its frivolity, so to speak, or Rule 11 federal. In the state system, that's known as Florida Statute 57.105. And 57.105 is tough to get judges to enforce, actually. I just did a pitch to a judge about how if you don't enforce a rule, then according to Oliver Wendell Holmes, the rule is what the bad man gets away with. It's called the bad man theory of the law. That what people want to know is not what the rule book says, but what the the sovereign or the courts are going to do. And if the courts don't do anything against frivolous lawsuits, then the rule is that frivolous lawsuits are allowed, despite the written rule that says they're not allowed. That's all on the Holmes path of the law about 1890. So, but it's very tough. And just like just like Palmetto Bay would claim that the fact that an appellate panel first upheld Palmetto Bay before another one reversed Palmetto Bay shows that Palmetto Bay did not act in bad faith, probably the average state judge is going to take those Third District Court of Appeals opinions and hopefully say the right thing, which is that doesn't violate due process, that doesn't prove any of that. However, it does have the language in there about Palmetto Bay having, these are just from the opinions, acted, without evidence, so the stuff that is normally said. But I doubt if a judge would, in light of those opinions, go in the other direction and say that the lawsuits were completely frivolous. Although I think Hoffman might think they are, and Hoffman is your lawyer on these lawsuits. And I think it's 2 lawsuits probably instead of 3.
It may give them pause for thought rather against launching these type of...
Well, the good thing about 57-105 is that it's supposed to be paid half by the lawyer and half by the party, which is...
That sounds good to me.
Anyway, I'll leave it at that. But it's hard to get. It's hard.
I just really appreciate hearing your point of view about the lawsuits, and I really wish that everybody in Palmetto Bay could hear this information. Is this it is obviously being recorded, is it going to be available? Yes, on the village website. I mean, it's just so important, and I can only presume, but please confirm that all of our village council members have heard exactly what you said, and this position, your position about the lawsuits. There is so much misinformation out there about the lawsuits, and I don't really feel that our council members necessarily fully understand what you have just said about the lawsuits. I also really appreciate your position and your point of view, which I think really needs to be out there in the community, that it's okay for the people to, that's sort of their job to bring the lawsuits, but it is up to our council not to be intimidated by the lawsuits and not to bend their votes based on the lawsuits, because I think that's what's happening in this village, and it's very disturbing. I wish everybody in this room would write to neighbors, would talk to their neighbors, would get this information out there. This meeting is just really important. The information that's being heard here is really important, and I thank both you and Councilwoman Lindsay. No, you have not overstayed. Stay right here. I just want to assure you, Mrs. Reed, that we have a gentleman in the back, our own Palmetto Bay resident, Hal Feldman, who is taping this for us, and I will let you know where you will be able to view the tape or to share that information with other people in the village so that they will be able to see this. Additionally, as I told you, the PowerPoint presentation that I'm in the middle of right now is available by clicking on my picture, and Mr. Lehtinen's presentation is also available by going to our village attorney's page on our website. Now, I know some of you have more questions for him, so I'm going to give the mic back to him.
Yes?
Controller. Good evening, Councilor. Thanks so much for being here. I'm going to follow up with the young lady's question there one more time. Have you had the opportunity to sit down with all the council members and explain face to face what you just told us tonight? I'm not sure if that question was ever answered. So.
It's been discussed and so forth. One of the reasons the report was written was to make sure that even though I say they're not complicated, actually sentences can be complicated, and so that's why the report was written. And, you know, all kinds of people I've dealt with, which is all five, have listened carefully.
Thank you.
People up front.
I'm Jerry Sheedy. I wanted to follow up on the original concerns of Palmetto were the 30-year moratorium and the student population. At one time, the moratorium had to deal with the slow growth, where they would put, I believe, 40 students per year on until they reached their required number. And I was wondering, is that part of the settlement that Palmetto?
The Palmer Trinity appealed and successfully appealed the number and got 1150, and appealed the 30 years and got that eliminated. I don't recall exactly what's in that yet.
If you will go to the village website and go to the litigation page and look up the resolution from the 2012 hearing, which is Resolution 2012-64, you will see that part of that was a schedule for enrollment, and that is part of the 2012 resolution. And Mr. Lehtinen, perhaps you could address the effect of the 2012 resolution on the proceedings that we're looking at coming up.
The 2012 resolution is the applicable regulatory structure for Palmer Trinity today. What the council chooses to do with respect to some things, I think most people know, there was I think the site plan has a 50-foot setback instead of 75 on some shrubbery and things like that, although that's all going to be prevented. And we would, in the normal course of events, see whether or not any of the matters you're referring to are part of the application. But at the present time, our hope is that it's just a site plan and not significant changes to the development agreement. Unless, of course, that's what the council wants, and we just do what the council wants. But none of that is written in stone as to what they would get. And I guess the important thing is on June 11th. June 11th? No, there's a June 11th community meeting. Right, the meeting in which their application is to be discussed. That's an important meeting. Yes? Or, no, sorry, I thought he was holding his hand.
In the past, when there have been discussions regarding negotiations with Palmer Trinity, the subject of shade sessions has come up. Could you explain, perhaps to me and everyone else here, the ramifications of the shade sessions? Because it appears to me that everything that's done, we don't know anything about until it's finally resolved. Is that an accurate statement on my part? Is my understanding correct?
Well, the final action is not taken in the shade, but the state law, it's an exemption to the government and sunshine provisions that says that a public entity discussing settlement or strategy of current litigation can meet behind closed doors. And the key one there is strategy, because settlement you can understand, talking about this much money, that much money, you don't want the other guy to know. Strategy is a broader term, so public entity can meet in the shade and keep the sessions. They have to announce it, they have to start the meeting in the open, indicate exactly what they're going to discuss, then go into a private or confidential session, have it transcribed, and release that when the litigation is complete. Now, you don't have to meet in the shade. There's no requirement that meetings be in the shade, it's just permitted. And there's no requirement that the transcripts be kept secret until it's over with. That's permitted. There can be good faith disputes about what is and is not the subject of the litigation, because frankly, different parties, a plaintiff and a defendant, will commonly have a different view about what that litigation is about, not just with a municipality, but what it's about. And the narrow view is that litigation is about civil rights and monetary damages. The broader view is that Palmer Trinity is asking for more in connection with the lawsuits so that more might be discussed in the shade. I'm not, so to speak, a fan of that, but I don't think it's automatically bad faith. It's just at the closer edge of it. Shade sessions, in my limited experience, usually cause more consternation about things that people thought happened in them than what actually happened in them, because they're usually pretty boring. I would recommend that a discussion of this lawsuit in the shade be a discussion about money. But the word, I don't want to drag this out, but it's possible for the transcript to show other words, because somebody might say, well, Palmer Trinity's asking for X. What about X? And then if there's a discussion where it's determined that X is not an appropriate remedy for the lawsuit, that was not an illicit discussion to discuss it. It's kind of like when a judge dismisses a case for lack of jurisdiction. The truth of the matter is that judge had a hearing on that case to determine that that judge lacked jurisdiction, right? So there's this interesting phrase that a court always has jurisdiction to determine that it does not have jurisdiction. So in a shade session, the mention of some other subject with a conclusion that that's not appropriate for the shade session doesn't violate anything, because you had to actually have that discussion before you could say, well, okay, let's not talk about that. You know, but the transcript would have that in it because you decided let's not talk about it. So I'm just pointing out that there should be no extensive discussion of it in a shade session, but there might be discussion of it saying, let's not discuss it. Therefore, it was kind of discussed. Yes? Somebody?
Yeah, hi, how are you doing? First of all, I want to thank you for being here. It's been extremely educational. I had a couple questions. Number one is, since Palmer was able to build in 2012, does that mean that their site plan, and you'll have to excuse me, I don't know the correct terminology, their site plan is under the 2012 code, not the 2014 code?
The site plan that was approved in 2012 remains approved. If you change the code so that something that's in that site plan would not be approved now, it still remains approved in the site plan. Vesting rights and so forth.
Okay. So, do you know what the difference between what they given a new site plan?
They've submitted a new site plan that's to be, well, I think it's revealed now. Essentially, you could go see it, but it's going to be conveniently discussed on June 11th.
Do you know what the issues on that site plan is compared to the 2012 code? Or any changes that they're seeking?
It is my understanding, well,
I heard there was a setback.
Mr. DeSalle and I have a scheduled kind of agreement that we're going to meet at some point and both agree that the site plan doesn't violate any code. You're not automatically entitled to it, but it doesn't take a code change. Meaning, for example, if the setback is required to be 15 feet, and the current site plan has 75, and they're seeking 50, they have to get a site plan approval, but if the code setback is 15, there's no code change needed. And it is a tentative belief that having removed lights, it's tentatively believed or hoped that the site plan involves no code changes. If it does involve a code change, it's just going to be whited out and told no.
So if it does not involve any code change, do they still have to go to a zoning meeting and get it approved by the
If it
council?
does not involve a code change, A, and B, it's considered minor or insignificant, that can be granted administratively. The planning and zoning department, I believe, I don't want to speak for them, but I mean, I talk to them a lot, is of the position, and then I would eventually be concurring with it, that they are changes that may be easily approved by the council or may not be, but that some of them are not appropriate for an administrative granting. That it needs to go to the policymakers.
Give me 1 second. So if there's only one, if it's only a setback issue, can the rest of the site plan be approved administratively and that one differential go in front of the council? Because they're not approving the whole thing because it's within the code of 2012.
You know, that's like the 11th and 12th questions in the second chapter of the math book that are the
Sorry,
narrow
I'm
questions.
CPA, it
You
just
get the
happens.
first 10 because they're just equations, and you can't get the 11 unless how much water is behind the dam. That's a sophisticated question. I believe that if the site plan went before the council, I would have to check this, but the council could review the entire site plan.
Even though all within the site plan, 99% of it was within code and 1% was not.
Well, no, if the 100%
Okay,
has to be, all of it has to be within code. All of it has to be within code. It's just that if there was once a 75-foot setback and they want to go to a 50-foot setback and the code is 15, hypothetically, then they're clearly within code. They're like 3 1/3 times larger setback than the code, but they're smaller than their site plan. So that needs to be changed, and it's an administrative judgment that is a significant enough change that it should be approved by the policymakers.
And who makes that judgment call?
That's the elected council.
No, I'm saying who makes the judgment call whether it can be administratively done?
That's initially done by the planning director. It would be, if considered in any way close, reviewed in a discussion with the village manager and the village attorney. And there'd be some consensus. The interesting point is, I believe it's not, you want things done administratively to save time and council time and everything. But it can be a defect to do a significant change administratively. But I don't believe it's a defect to do an insignificant change through the quasi-judicial proceeding. In other words, anything you do quasi-judicially will be supportable with evidence. So.
Have a question? Mr. Lehtinen? Sort of following up on the comment by Mr. Singer, I think a lot of the people in this room are, at least I am, sort of shaking in my boots, thinking that this decision might be made just administratively. Originally, I understand the original suggestion was a 75-foot buffer. Now the request has been reduced to 50, but it really isn't a 50-foot buffer because they have proposed to put a path in the middle that would be a running path and also a maintenance path. So now that 50-foot buffer becomes less than 25 feet between the property line. Now, maybe legally, that would be within the parameters of 15 feet, but it seems to fly in the sense of anybody's sense of decency and common sense that once if you agree to go from 75 to 50, and then you bifurcate the 50, so it's even less. You've basically given perhaps at most 20 foot. You know, so to say, oh, well, we agreed to a buffer, let's not kid ourselves. It's not a buffer, if it's pierced by a maintenance path. So, I mean, it really makes me feel very uncomfortable to say, well, legally, they only need 15 feet. But it applies in the sense, again, of not negotiating this school in good faith with the people. Can you address that concern?
Well,
Or should other people have it?
that's really an issue on the merits that will go to the council. I don't know that anybody's made a decision on that, but I would, and I don't know if it's wise for me to say that as far as I know, that's going to go to the council. Well, actually, that's accurate. As far as I know, it's going to go to the council. The next question is, how much do you know? But that will definitely be considered and understood.
But there was a petition, so you're saying it's up to the council. And could they be sued for saying, oh,
Well, everything is like in the end up to the council, but it's not going to be an issue if certain council members believe a certain change should come to them for a quasi-judicial proceeding, and the staff believes it should go to them for a quasi-judicial proceeding, then there's no issue. I mean, who made that decision? That's just there's no issue because there's no struggle. It would only be a struggle if decisions were made not to take it to the council on matters that one could argue is significant.
it's a very popular decision. So
I'm sorry, I just didn't hear. The unpopular part I know about that's government. It's in 17
no, unpopular to not require a whole, an unbifurcated or undisturbed buffer, so it truly is a buffer. And their proposal now is really, it's a joke, because it's not really a buffer of 50 feet. So,
Well, it's not my place to say that, but whoever goes to the June 11th meeting probably wants to clarify.
So, but legally, could they deny this if they're only required to have 15 feet?
Well, it's, that hearing is supposed to be based on substantial competent evidence. You proffer what you believe will be shown at the time, but depending on what else is shown at the time, I mean, it's not an evasive answer to say, yes, they can deny that, depending on what they hear in the hearing, or they can grant it depending on what they hear in the hearing. That depends on factual matters. I think what you said is clearly relevant to the hearing, that something goes on in between the 50 to the 0, that something else goes on. So as you're arguing, the setback is really different and so forth. I mean, all of that is relevant. Just difficult to say right now what one would conclude.
It goes back to 2012, zoning.
But
It goes back to 2012.
no, it goes to the zoning code today. They're applying today.
Mr. Singer, I have the mic.
They are applying today. I mean, they're applying today, so it's the code today. Actually, the code when they apply, which is today. In a month.
Mr. Lane, I thoroughly thank you for your presentation tonight. It was very educational and very enlightening. Thank you. Following up on one of Mr. Singer's questions, let's say if, the only change was the site plan change from 75 to 50 foot, and if they took the running path out of it, it was a true buffer. That was the only change, that they go through an administrative change and not come back to a quasi-judicial hearing. Does that mean all of the other conditions built into the 2012 resolution would have to stay with no changes?
The last question first. The 2000 resolution stays in place except as explicitly changed. 75 to 50 is an explicit change, so that would be an explicit change. Everything else stays except as maybe explicitly changed, but I'm sure there's more than that on the site plan.
We ask
More changes than that.
a follow-up question to that. There was a number of call it, conditions built into the resolution involving traffic. I understand that Palmer Trinity is not going to do a new traffic study. So the study they did with all the changes that were put in there with competent staff, substantial evidence at the 2012 hearing and the hearings before that, all of those conditions have to stay on traffic unless they want to change the traffic, which would mean a whole new traffic plan, as I understand it, or a whole new traffic study.
It's been the village's position, the planning director's position, and my position, planning director is more important, that if any change is made that affects traffic, they would be opening themselves up to a new traffic study. If they make no changes that affect traffic, then they're not required to do a traffic. It's what you change.
Okay, so there's like 20 things on traffic built into that 2012 resolution, so they all stay. They can't, they were all put in there under competent substantial evidence, so those can't be changed. If they don't want to do a new traffic study.
But, I mean, they're not going to be changed. They can't be changed without a...
Thank you.
Yeah, can't is cannot is a odd word there, and I've testified as an expert witness many times, so I know kind of where you're going. But if there is a change, if there is any effort to change anything that relates to the traffic, they open themselves up to new traffic. So it is highly likely that all traffic restrictions will remain. It's not my place as a lawyer to say it, but I don't think they want to do another traffic study. So I think they're going to opt for all of the current restrictions staying right like they are, rather than getting tougher ones, which is probably what they might strike at, which is what they could open themselves to if they didn't another study.
Yes, if this lawsuit went to trial, how do you think? Do you feel that we would prevail and possibly collect attorney's fees?
Well, I can give you the answer that the more experienced people, at least like Hockman would give, which is, there's always this and we can't expect it. So the A, B, C, D, E, F, the qualifiers you expect, I don't think you would lose, as long as you allow me to fill in. The qualifiers you would get, like you don't know the particular judge, you might hear the case, you can make those qualifiers up. But Hockman is fairly confident about the village prevailing. Of course, there are a few things that we don't know about. Did somebody do an ex parte they didn't reveal? I don't think they did, but I don't know. It was their public record you had that you didn't give village. Hockman and I think no, but if we're Perry Mason and all of a sudden the witness pops up with something. But generally speaking, based on the complaint and what they know, Hockman is confident. He believes the chances of losing are small. And the chances of not being covered by sovereign immunity and therefore, or your policy, therefore facing significant damages is even smaller.
So as far as the current $800,000 Palmer Trinity settlement, that really then is excessive and pretty much off the table?
Yeah, that number is made up of a certain actual one and then credits for future applications, something to that effect, right? Less money and more future credits, which is like...
So we are no longer committed to that?
Well, you were never officially committed to it. The council voted to move in that direction, and it could move in that direction with money if it chose to. But it doesn't have to.
Marzena Schindler, I have just one question. Obviously, I'm not a lawyer. I need to ask a lot of questions. This one is a very simple one, because we see the Palmetto Trinity, in order to get to reach their goal, approaching us like a fox from different sides. Is there any limitation to what they are doing? No limitation?
Yeah, there's limitations, significant limitations.
Okay.
They got, they can build according to their current site plan. They have to ask for permission to change the site plan. Some of the requests may be reasonable. I mean, and are granted as a matter of policy. Changing the code is much harder to do. That's a discretionary legislative act. By the way, when we talk about quasi-judicial, it's not to sound fancy. It's just that the change of the code is a purely legislative act, which roughly speaking, setting aside racial discrimination and certain other motivation, roughly speaking, legislators can do what they want. Whereas the quasi-judicial, the site plan change, is supposed to be, according to the Florida Supreme Court, a decision based upon the application of law and evidence related to that law. So it's, the council is not free to simply say, if it was a legislative choice, I'd vote no. Instead, there's supposed to be judges and vote based on the evidence. That is a little difficult to figure out when you're talking about what's the evidence on 75 or 50 or what's the, but such matters as were discussed, that evidence that shows that it may be within the setback, may be used for something else, so it's not a setback. I mean, but there have to be reasons. Legislators don't need reasons, as long as they're not acting on.
One more question about...
But judges do need reasons. Sorry.
One more question about the costs. When we are paying some money to them, and we have, of course, our insurance, what about our insurance premium?
That I don't know. Who pays the premium? I mean, the taxpayers, but who writes the check? Finance.
So thank you.
Finance. I don't know your premiums, and I don't know their. You mean like you have an auto accident and raise your rates? That's what you're talking about? Yeah. My USAA, they're better. Not better. Good. Thank you. Thank you. I'm sure that was too long.
I'd like to thank Mr. Lehtinen myself. I think he did an outstanding job, and I hope that you all have learned a lot.